Good afternoon, everyone. Welcome to the Inn of Court. My name, as David said, is Donal Lunny, and I'm the chair of the Bar Council of Northern Ireland. I'd like, first of all, to thank the Lady Chief Justice for her attendance this afternoon, and I, like all of you, look forward to hearing her opening address very shortly. Thank you also to the Human Rights Commission and its Chief Commissioner, Alyson Kilpatrick, for the valuable and continuing collaboration with our bar on this, the annual Human Rights Lecture. I'd like to welcome all of you attendees here today, particularly those who are visiting the Inn of Court for the first time. And we also, as David said, have a significant number of people joining us via the live stream. So a virtual welcome is extended to you too. And I would, of course, most of all, like to extend a very warm welcome, or perhaps more accurately, a very warm welcome back to Belfast, to this afternoon's keynote speaker, Dr. Michael O'Flaherty, the Commissioner for Human Rights for the Council of Europe. Dr. O'Flaherty's role is the most senior non-judicial post ever held by an Irish citizen in the Council of Europe, and we are hugely grateful that he has given up some of his valuable time to share his knowledge and insights with us here today. As you probably know, one of several important duties of the Commissioner for Human Rights is to promote education in, awareness of, and respect for human rights in the Council of Europe member states. This is laid out in the 1999 resolution that created Dr. O'Flaherty's office. Similarly, our Human Rights Commission is mandated under Section 69 of the Northern Ireland Act of 1998 to promote understanding and awareness of the importance of human rights in this jurisdiction. Our bar is very pleased through today's event to assist both the Commissioner and the Commission in going some small way towards fulfilling this crucial mutual objective. And whilst I can't personally hope to contribute to today's educative purpose, I can offer a number of brief personal observations and reflections on the convention for what they are worth. When I studied human rights law at university back long ago in the mid-1990s, it seemed like an area of law that was only to be litigated in exotic places like Strasbourg rather than before our domestic courts. Even then, however, there were domestic commentators decrying the decisions of the Strasbourg court and saying things like Britain must resist this court and remove itself from the convention. So there have been, I suppose, some constants. Then, of course, the Human Rights Act was passed in 1998, the year that I was called to the bar, and so much then changed. Convention rights have been a feature of practice here for the last 25 years. They've even worked their way into some of the more arcane areas of my practice. A quick skim this morning through the most recent page on our Judiciary NI Judgments website reveals that convention rights were referred to in at least half of the judgments delivered by our courts over the last 4 weeks. And those are judgments that cover a broad spectrum of the legal field, from crime to judicial review, to inquests, and even personal injury claims. Many of our colleagues here at the Bar of Northern Ireland have, over the last 2.5 decades, gained unrivalled experience and expertise in arguing convention points before UK courts. I firmly believe that this is a feature of our bar of which we can rightly be immensely proud. It's an accomplishment about which we should, perhaps, with a nod to our English colleagues, boast a little bit more. Last term, we had the huge benefit of a lecture from Lord Reid and Lord Stevens from our Supreme Court, celebrating that court's 15th birthday. They told us how, in terms of numbers of cases before their court, Northern Ireland punches well above its weight, and human rights points, we know, feature in the lion's share of those cases. Testimony, I submit, to the expertise and experience that exists in our bar in this field. Of course, we're all conscious that life as a lawyer necessarily involves constant learning. Just as society changes and new challenges emerge, so the law evolves, and so must our learning. And with that in mind, I will bring my brief contribution to this afternoon's fantastic event to an end and hand you over to the lawyers who will actually assist you in that educative task. So I'd therefore like to welcome Our Lady Chief Justice, the Right Honourable Dame Siobhan Keegan.
Well, good afternoon, everyone, and thank you very much for inviting me back. I think this is the third annual lecture that I've been asked to introduce, and it's always a pleasure to do so. Thank you, Donal, for the introduction. This lecture is a very important lecture within Northern Ireland. We have it obviously on an annual basis, and there's a reason for that. The speakers, as you will see if you trace the history of the lecture, have been prestigious. This year is no exception, but they've also placed a spotlight on important human rights issues and challenges that we have. I want to add my own personal welcome to this year's keynote speaker, Dr. Michael O'Flaherty, the Commissioner for Human Rights of the Council of Europe. Now, I'm sure Alyson Kilpatrick will provide a more detailed introduction to Dr. O'Flaherty's remarkable career. I'll simply say this: it is clear that he has dedicated his life and career to protecting human rights through the law, and I know that his lecture this evening will be captivating and inspiring. Today's topic, the rule of law and human rights, has been a subject of dedicated discussion and research for centuries, and rightly so. The concept of the rule of law forms the bedrock of the modern legal system and is frequently cited in courts across Europe. Yet it faces constant challenges in contemporary society. From age-old conflicts or emerging issues such as artificial intelligence or climate change, the rule of law continues to be rigorously tested. What does it actually mean? Well, when thinking about the meaning of the rule of law, a personal point of reference for me is the writings of one of my predecessors, Lord MacDermot. In 1957, he delivered the Hamlin Lectures on the subject of protection from power under English law. In his introduction, he set out his personal vision of the law, stating, to quote, "The law should enshrine the rule of law, which is the badge of a free people. It stands for equality before the law, for the independence of the courts, for the absence of arbitrary government, and for established sources of law." This interpretation of the rule of law has been subject to analysis and development by other jurists. One notable example is Lord Bingham, who in his 2010 book, The Rule of Law, expanded the rule of law to include 8 principles. His 5th guiding principle is particularly worth recalling in the context of today's lecture. That is that the law must afford adequate protection of fundamental rights. That guiding principle, of course, finds expression in the European Convention on Human Rights, but it is also embedded within the ethos of our common law. My very brief summary reminds us, I think, that the rule of law concerns both substance and form. It also is it is also reminding ourselves of the elements of the rule of law that I've drawn from Lord MacDermot's Hamlin Lectures to include the independence of the judiciary and also adherence to substantive law, which is itself based, as I've said, on common law and international standards. There are many cases, as Donal has said, within this jurisdiction which have dealt with human rights issues recently. But back to first principles, it seems to me that is no surprise in recent times. Any background to the human rights discourse in Northern Ireland draws from the Belfast or Good Friday Agreement. The agreement frames the human rights perspective in Northern Ireland. And this is because, as you will, I'm sure, know, the agreement was prefaced on the European Convention of Human Rights, which of course responded to the grave human rights breaches which occurred during World War II. The Good Friday Agreement was given legislative imprimatur and effect through the Northern Ireland Act 1998, and it therefore strengthened anti-discrimination and equality legislation in Northern Ireland. Of course, as we know, the agreement established the Northern Ireland Human Rights Commission and the Equality Commission for Northern Ireland as dedicated mechanisms to oversee its implementation. Importantly, both commissions have procedures to invoke the accountability of the state, for instance, by initiating judicial review proceedings when issues which affect the rights of the community arise, and they frequently do so. In the same year as the signing of the Belfast Agreement, the Human Rights Act 1998 was passed, incorporating the European Convention into domestic UK law. Section 4 of the Human Rights Act bestowed an important power on the courts, enabling the higher courts to make a declaration of incompatibility if legislation cannot be read down in a convention-compliant manner. The Human Rights Act is clear, however. This power does not disapply or strike down offending legislation, as this is a function reserved in the human rights context, not to the judiciary, but to the legislature as the elected branch of government. Therefore, the separation of powers is preserved. I thought it would be interesting to tell you that the number of declarations of incompatibility which have been made since the Human Rights Act came into force is, on the last information I've received, 2023-2024, a modest 58 or so. That's across the UK. This figure elucidates the facts that we interpret law in a human rights compliant way to start with, and then we also take care to grant a declaration of incompatibility as judges when circumstances arise. The overarching feature of this position is that an independent judiciary is able and must be able to rule on the legality of legislation when issues arise. And that, drawing back to what Lord McDermott said, is an important aspect of the rule of law. I'm not going to speak about particular cases today, save to say that the courts, when dealing with these types of cases that come before the court, realise that the context of them is important. As you can imagine, as Donal has said, human rights cases arise across very many areas of law. And what the courts have said in a number of cases is clear, that the role of the courts is not to make policy. The courts are simply concerned with the legality of legislation before it. This is a legitimate part of the judicial function, reflective of adherence to the rule of law and the constitutional role of the courts, recognised both at common law and in legislation. I'll finish in relation to another aspect of the rule of law. The balancing exercise that courts have to undertake when looking at human rights cases is strong. Recently, in one case which dealt with a family law context, the court had to look at Article 6, Articles 8 and Article 14 of the European Convention on Human Rights. This was in relation to parental responsibility for children. And the court did look at this very clearly and looked at the issue of whether there was differential treatment of married and unmarried fathers within a policy context, and found that the Children Order, which incidentally has withstood very many human rights challenges because of the way I think it was firstly drafted and secondly interpreted, the court decided that the order balanced competing interests in relation to this issue, and also referred to the state's margin of appreciation in deciding that there should be a differential between married and unmarried fathers. As I've said, I'm not going to deal with any other cases today, and I'll leave you to Dr. O'Flaherty and his talk, which I think will elucidate this area for us. But finally, by word of my own position on the rule of law and protection of human rights, it seems to me that this is well known and embedded within our judicial system. It is subject to challenge. It might be difficult to maintain from time to time. That's because there are a number of competing interests and issues at play. However, to borrow from Lord Bingham, who I have also quoted in this brief introduction, the function of independent judges charged to interpret and apply the law is universally recognised as a cardinal feature of the modern democratic state, a cornerstone of the rule of law itself. On that note, I finish, and I thank you once again for inviting me to speak on this very important topic. Thank you.
So I also want to join in welcoming you and thanking you for attending both in person and online, and for showing your interest in human rights. It's particularly pleasing that you come from different walks of life and different disciplines. We could sit in pre-selected groups and congratulate ourselves for our commitment, but that's not what we're about, and it doesn't advance human rights. We're about protecting, respecting and promoting human rights. And now more than ever, we can't take it for granted that human rights are understood, appreciated or even trusted. Every opportunity we get, we must take to advance them. Lady Chief Justice, thank you very much for speaking today, but also, can I say, we're honoured and grateful yet again for your leadership of the legal profession and across Northern Ireland, and for your dedication to the rule of law demonstrated without fear or favour. Without such leaders in our legal profession, human rights are meaningless. The rule of law is something we all say we agree with, but which is sometimes easier in the statement than in the demonstration. The Human Rights Commission's annual lecture is an opportunity to reflect on the challenges facing human rights, and therefore which go to the heart of challenges to the rule of law. This year, those challenges are not nuanced, they are existential. We face challenge to the very notion of human rights, certainly to protection of rights that are universal and inalienable. There's more our people and their people than I can remember in a very long time. Our people, of course, deserve everything there is. Their people, not so much, if at all. Only when our people have everything they need can we afford to give to their people. This is also seen in the discourse about fundamental rights. We've been played off against each other. Rights are set up to be competed over. The prize is allocated according to strength. The strong win, the weak accept their lot. Our people and their people can be heard within houses, schools, doctor surgeries, on the streets, in the shops and banks, between cities, countries and counties. It's apparent on the internet, in the media, in politics. It's about allegiance to an address, a class, a sector, a religion, a philosophy, who knows, what it will be next. And that's how we tend to work. But that's precisely why human rights afforded to each and every human being, simply because they are a human being, are so critical. They are the great leveller. Universality means that all people must enjoy fundamental rights equally. No person has to earn those rights, and no person loses them by virtue of their status or their behaviour. Many rights may be limited, but only in clearly prescribed circumstances, and only so long as it's reasonable and it is done proportionately. Inalienability means we enjoy all of the rights. Some rights may well play second fiddle to others in certain circumstances, but not without due consideration, a proper rationale, and ultimately because it is reasonably necessary to do so. The Human Rights Commission started out as a result of the Belfast Good Friday Agreement, which promised a guarantee of true equality and that civil rights and freedoms would have special and enduring significance in Northern Ireland. That hasn't changed. Human rights were to run through everything. That, we were told and we believed when we voted in the 2 referenda on the island, would ensure a peaceful society in which all could flourish and reach their full potential. It's no coincidence that the agreement was underpinned by the European Convention on Human Rights. The Convention was informed by and concluded to avoid repetition of some of the worst human tragedy ever seen. There appeared to be no low to which humans were not capable of sinking, so long as some sort of plausible justification was presented for it. To that can be added a sense of fear and loathing of others. Stripping others of the common characteristics of humanity makes it easy, and often goes like this. Some people, they don't feel the same as we do. They don't appreciate decency and manners the same way we do. They don't love their families or children the same way we do. They don't contribute to society as we do. They don't have the same belief system as we do. They can't even enjoy the rights, really, that they're given in the same way we do. And in any event, why should they get what's not theirs? And I suspect at some point we have each flinched when we realise that something like that has entered our heads. It's natural. At some point in our lives, we're easily frightened and we feel vulnerable. But as I say, because it's natural, there has to be something to protect us from our own worst instincts. We must remind ourselves and others that when something bad happens, the state may take a leap towards securitisation, protectionism and exclusion. Very quickly, we can be taken hold by a fear of newcomers and people from different backgrounds. We're persuaded that human rights can be limited for a time or for a certain group. When that's not challenged robustly, it beds in. The denigration of the rights of a few becomes the denigration of society as a whole. Human rights protection has to be enforceable, and it has to be enforceable easily. The enforcers must be beyond reproach. Lawmakers themselves must be subject to enforcement, and we must truly believe that we're all stronger if each other enjoys the same protection. The state does not get to do whatever it wants. That's not democracy. The state must approach its policy and lawmaking from the starting point that it has obligations to protect and fulfil human rights, regardless of political expediency, regardless of whether they're likely to get caught out and or get taken to court, and regardless whether the right thing to do is also the most popular thing to do. The principles are clear, but the application has been piecemeal. The rationale for universal rights seems to have faded from memory or been replaced by disinformation and propaganda. It has been completely upended. Rights are not rights at all. In some corners, they are rewards given out by those in power. The backdrop of this year's lecture is a further rise in the number and quality of threats to the rule of law, to the very notion of human rights and to democracy itself. Across the globe, we see a rise of populism, and with it the spread of anti-human rights rhetoric, deepening inequality, and the increasing marginalisation of vulnerable groups. There is a complex interaction of factors that have implications for each of us at home and also as actors on the global stage. However hard we try, we will not tackle anti-human rights rhetoric alone. Social media and other emerging technologies mean there are no walls or borders. What affects one of us will affect the rest of us. It's critical that we maintain close relationships with our friends and neighbours here and further afield. We must collaborate, exchange ideas and expertise, and form a united voice for human rights. Northern Ireland has benefited from close collaboration over the years and support across the Council of Europe, and we, its human rights institution, has kept going and now thrives thanks to that support. And as we know, true democracy is not a numbers game. It's about attaching the same value to each individual, particularly if they do not form part of the majority. The state must have a particularly keen responsibility to those who are isolated, marginalised and vulnerable. The state must value and protect the rule of law even when we can't see what they're doing. Northern Ireland is an inspirational but also a cautionary tale. We embrace the rule of law in a way that others looked on with envy. I travel a lot in my work and I hear that firsthand. However, we are not immune from the rollback. We see both the historical and the contemporary relevance of human rights being tested here, and we will see this increasingly. We see it in the approach to migration and to migrants, in dealing with the past and closing down the care package of measures, in the toleration of racism and violence against women and girls. We see it when paramilitaries may be preferred over others, when intelligence may be preferred over justice, and when people are harassed or hurt because of their sexual orientation or gender identity. Northern Ireland has been responsible for some of the seminal cases before the European Court of Human Rights, and we have spread the experience of peace based on human rights compliance around the world. We did that despite ongoing brutality, inhumanity and suffering. We are still a great inspiration to others, and we must continue to be proud of that, not sneer at it. If not, our very democracy and national security are at risk. We do not enhance security by limiting rights or right holders, another mistake commonly made. And I'll finish with the words of David Anderson, KC, Lord Anderson. Many of you in this room will have met him. He was a former reviewer of terrorism legislation. He said this: "The convention was forged in the aftermath of war, as despotism and liberalism strengthen around the globe, and new war rages. The world is engaged in a battle for hearts and minds, a battle which our national security depends on winning." He continues, "The European Convention embodies the values that we have helped project across a once divided continent. To abandon it now would be to cast aside our compass in treacherous terrain, and to signal to newer democracies than ours that no compass is needed. That would be an act of the purest folly." So I'll end there with a few thoughts of what can only be described as a visceral nature, maybe too visceral in nature, but you will now hear from, you'll be relieved to know, from Dr. Michael O'Flaherty with a much more structured and elegant speech entitled "Uphold the Rule of Law, Resist the Pushback." But first, a few words about Michael. Michael was elected by the Parliamentary Assembly of the Council of Europe in January 2024. An Irish human rights lawyer, Commissioner O'Flaherty has served as the Director of the EU Fundamental Rights Agency for a number of years, as a member of the United Nations Human Rights Committee, as Chief Commissioner of the Northern Ireland Human Rights Commission, nice to have you back, and in various posts at the Office of the United Nations High Commissioner for Human Rights, notably in setting up operations in conflict-affected countries such as Sierra Leone, Bosnia and Herzegovina. Commissioner O'Flaherty has held professorships of human rights at the Universities of Nottingham and Galway, where he has also led their human rights centres. And if that wasn't enough, he's currently adjunct full professor at the University of Maynooth and University College Dublin. It's so good to see you back in Belfast, Michael, and to see your leadership across the Council of Europe. I think it's testament to you that, that we have 5 previous chief commissioners here. I think that's the first time it's ever happened. And I wonder if, like Doctor Who, we all combust or something, if we're in the same room together. But you're very welcome. Thank you.
Alyson, thank you very much indeed for the warm welcome. Lady Chief Justice, Chief Commissioner, Alyson, Commissioners, former Chief Commissioners and former Commissioners, Chair of the Bar Council, dear friends. I'd like to thank the Commission very much for inviting me to deliver the 2025 annual lecture. I'm delighted to be back. It was one of the great honours of my life to lead the Human Rights Commission already over a decade ago. I learned much from my fellow commissioners and from the very gifted team at the Commission. I saw how it contributed to the consolidation of the Belfast Good Friday Agreement and towards the embedding of fairness in public service in this jurisdiction. And I've watched with respect and some pride at how it has come to play such an important role in Europe and much more widely, including across the Commonwealth. The Commission, in other words, has demonstrated the important role of national human rights institutions for the well-being of any society. These institutions constitute elements of the architecture for a healthy democracy. They are components of that post-World War II revolution in building a social model that serves, does not subjugate, the human. The immediate story, of course, begins with the Charter of the UN, the adoption of the Universal Declaration of Human Rights, the negotiation of numerous human rights treaties, and a suite of other initiatives in support of democracy and rule of law. Here in Europe, the Council of Europe has for 75 years played an essential role in presenting, defending and promoting those three core and interlocking concepts of human rights, democracy and rule of law. Together with the OSCE and the European Union, they have elaborated their own standards and have developed numerous institutions in support and in furtherance of human thriving. The totality of the efforts of the UN and the regional organisations is to clarify an understanding of and affirm the validity of that interplay of democracy, rule of law and human rights. Now, we lack in the English language a noun to capture this interplay, to describe a state that integrates the three elements in an interdependent and indivisible form. The Germans have various words, as do the French, but we lack them in English. And so today I will generally use the term rule of law as a kind of a shorthand for the interplay of all three. And by the way, in terms of definition, I will not forget what the Lady Chief Justice reminded us were the words of Lord MacDermott. I think it's a beautiful term, the rule of law as the badge of a free people. Now, states have invested in oversight mechanisms intended to promote respect for rule of law. The investment is long-standing when it comes to human rights, including in the activities of the European Court of Human Rights, other regional human rights courts, and of numerous human rights promotion and protection mechanisms. The international developments are accompanied, of course, by national initiatives, including the establishment of national human rights institutions, equality bodies, and other entities of that kind. Beyond human rights, attention to oversight of rule of law more generally is more recent. But there is, for instance, the Council of Europe's Venice Commission, which has elaborated a checklist to assess compliance with the rule of law. And then the EU, in its own turn, has instigated a rule of law compliance assessment system for its own member states. Importantly, the intergovernmental and state commitments in these areas is reflective of strongly held views in our societies. The results of a 2023 global survey by the Open Society Foundations I find particularly revelatory. They surveyed 36,000 people across 30 countries, finding that 86% of people say that they wish to live in a democracy, and 72% said that they believe that human rights are a force for good. Indeed, 71% said, and I quote, "Human rights reflect the values that I believe in," unquote. And these findings echo the results of surveys conducted across the EU by its Fundamental Rights Agency. Now, from this brief and short review, we can conclude that the establishment and consolidation of the rule of law is a notable achievement, all the more so for having emerged from the chaos and the horror of war. What's more, it has unique qualities. Above all, it is the only model for society that can be said to have the universal agreement of the world's states, as evidenced, at least nominally, in the outcome declarations of repeated global and regional summits, such as that in 2023 of the Council of Europe gathering of the heads of state and government. But my friends, so far so theoretical, you might say, with these impressive ideas often very far from the reality of the lives of millions of people. And you would, of course, be right if you thought that. We still have such a long way to go to realize the dream of a world where everyone is equal in dignity and in rights. The vision of the UN Charter is unrealized. States ebb and flow in their commitment to and respect for rule of law. Progress is rarely linear. Achievements fall apart and are undermined. And right now, the Russian aggression against Ukraine testifies to what happens when the values are insufficiently embedded. How much damage can be done by an aggressor bent on conquest and destruction. What is more, and focusing just on Europe, and as we already heard, especially from Alyson, in recent years and in too many places, we have seen an insidious withdrawal from central tenets of the rule of law. We see it in the agendas and the actions of far-right political groups. Just listen to the voices of politicians in Germany literally this morning. But these then in turn acquire their places, these voices, they acquire places in parliaments and governments where they seek to undermine much of what has been achieved. They attack institutions, they fill them with their own supporters, they starve them of resources. Their attention typically then turns to those at the edges of our societies, whom they problematize, whom they render as other, identify as the cause for all the malaise of our states. Right now, the primary target for this othering is migrants. Other groups under extreme pressure include the Roma community and LGBTI persons, especially I think of trans men and women. Civil society defending such groups are exposed to particular challenges. Efforts are made to block a free media and to consolidate media freedom or media ownership in the hands of one's supporters, or indeed, in many cases, of one's bankrollers. The playbook of those who attack our institutions grows ever more diverse. Today, also embracing school curriculum reform and the replacement of the leaders of cultural museums like galleries and museums. Everything is accompanied by disinformation that is actively promoted on social media platforms that themselves are failing adequately to police their spaces. And evidence suggests that across these phenomena, and at least as regards Europe, one state, Russia, plays a particularly pernicious role. An especially disturbing development, notably observable in the past year, has been the embrace by some politicians from the political middle ground of ideas that are antithetical to the rule of law, presumably for electoral purposes. So far, we have seen this most obviously in the context of migration management, where parts of the political centre join with the extreme right to denigrate asylum seekers, blame them for our society's ills, and advocate such breaches of international law as summary returns across borders and violation of the principle of non-refoulement. I describe this new willingness of the political middle ground to compromise on principles as especially disturbing because it is to it that we look for firm commitment to and leadership for the rule of law. If the middle ground, even in part, withdraws its commitment, then, as the poem of W.B. Yeats' The Second Coming puts it, things fall apart, the centre cannot hold. And all of this now, of course, plays out against the backdrop of the actions of the new US administration, which, for instance, through withdrawal of USAID funding, is already negatively impacting the operation of European civil society and independent media. US-sourced rhetoric also seems to embolden those who denigrate the trans and other minority communities. A critical moment came with the speech of US Vice President Vance at the Munich Security Conference on the 14th of this month. Mr. Vance, addressing Europe, or at least its leaders, implicitly rejected our understanding of the rule of law. Seemingly defending an absolute form of free speech, he described EU and other actors as being like Soviet-era commissars in their quest to tackle disinformation. He was no less scathing in his denigration of efforts to regulate in the interests of human well-being. With his reference to the removal of firewalls, in a speech in, of all places, Germany, he seemed to identify extreme right-wing groups as the voice of the people that must be respected. And he concluded that European leaders should, and I quote, embrace what your people tell you even when it is surprising, even when you don't agree. And if you do so, you can face the future with certainty and with confidence, knowing that the nation stands behind you. End of quote. And as I've said elsewhere in recent days, I reject the analysis of the US Vice President. Europe, for all its failings, can be proud of its efforts to uphold values that are underlain by human rights. We seek to uphold a right of free speech as it is mapped out in international human rights law, a right that certainly is fundamental in importance, but the application of which is subject to limitation. And as to his reference to the voice of the people, I'll come back to that in just a moment. Colleagues, the delivery of that speech marks an arresting moment, a time to wake up to the acute danger for our societies. It somehow crystallizes the peril. It shines a light on the prospect of losing the formula for peace and well-being that, for all its limits and its under-delivery, serves us so well. That is not something we should even countenance tolerating. We have to, in the words of the late French writer Stéphane Hessel, wake up and, as he put it, indignez-vous, get furious. But what should we do in our outrage? Let me offer a few brief suggestions this afternoon. In the first place, the saving of rule of law requires that our efforts be evidence-based. This, in turn, requires us to seek out and challenge the disinformation and the myths that infect the discourse. We need to call out the nonsense, dispel the myths. I already addressed the myth that our peoples simply are not interested in human rights or rights-respectful societies. Another set of myths concerns the primary target of populist ire, irregular migrants, who were also referenced by the Vice President. Study after study undermines the repeated claims that such migrants are primary drivers in Europe of crime in general and of sexual violence in particular. A further cluster of myths concerns the role of regulation, including laws intended to make our society safer. The myth is that such oversight impedes innovation, undermines global competitiveness, strikes at free speech, and it is being invoked with increasing stridency. But it simply doesn't stand scrutiny. Take, for example, the oversight of AI. It's increasingly clear that this is not the source of Europe's poor track record of innovation, which is undoubted, but that lack of innovation in Europe instead results primarily from such other problems as inadequately developed capital markets, onerous bankruptcy regulations, and more generally in Europe, a distaste for risk. Regarding regulation of social media, I'm very concerned by calls for a retreat, for instance, for a weakening of the EU Digital Services Act. Such instruments as the EU DSA do not undermine free speech. Instead, they defend it as it is understood in international law, a fundamental right that, as I said earlier, is subject to carefully constrained limitation in the service of the public good. Also, I deplore the abandonment of content moderation on the part of some digital platforms, the effects of which are already visible in the proliferation of criminal-level hate speech and malicious targeted disinformation. And recall how this form of absolute free speech hits hardest for women and for minority groups. One last myth to mention suggests that our populations are crying out for a shift to less tolerant and more closed societies, for a retreat from a vision of society that respects diversity and inclusion, away from a vision of a rights-respectful society. And again, this myth is very impactful, but it also does not stand up to scrutiny. Recent research shows, or at least suggests, that far-right populism is a top-down phenomenon, driven by political actors and fed by waves of disinformation. What's more, as that Open Society Foundation survey demonstrates, the levels of hate online are in no way a reliable guide to the views and the values of the general population. But next then, we must identify those actors that we need to rally, or that need to rally, in defence of the rule of law. The state is the key actor, and I will of course return to it in just a moment. But first, let me observe that the role of national human rights institutions and of other such entities as equality bodies and ombuds institutions is no less critical. I acknowledge their work with deep respect and appreciation. I continue to urge states that have yet to establish such bodies to do so without further delay. Frankly, it's unacceptable that there remain holdouts across this continent. We must also be vigilant in resisting cuts to their budgets, interference in their independence, or their effective sidelining in society. And remember that the health of a national human rights institution is a bellwether indicator for the condition of our rule of law states. The part played by civil society is equally essential, and as I have said, it is delivered with great courage and often at the expense of personal safety. The pressure under which civil society functions is unacceptable. It is deplorable that in so many places, so many activists, human rights defenders, and others confront harassment, violence, detention, exile, and repression through regulation. Standing up for human rights has to be a core task of national and international human rights bodies, and I see it as one of my highest priorities in my function. And now regarding the state, all of its institutions are engaged and on multiple fronts. Concerning the executive arm, let me concentrate today, this afternoon, on just one area. I look to the executive to do a much better job of honouring the indivisibility of human rights, according co-equal status to civil and political on the one hand and social and economic rights on the other. It is only if this is achieved that our general populations will appreciate that the rule of law is about and for them. Here I recall the legitimate disaffection within our communities. Progress has left many behind. There are very worrying levels of inequality in Europe. Until that is addressed, we both fail our people and offer electoral opportunities to those who would undermine our democracies. Obviously, and drawing on our shared experience, I realise that my ask is an enormous one, but we should see it as a long-term objective. And what's more, there are concrete things we can do in its service right away. For instance, we can be more consistent in demonstrating our own understanding of the unrealised vision of indivisible rights. But here I acknowledge in a special way the important work of the Northern Ireland Human Rights Commission, which through the annual Human Rights Statement strongly frames socio-economic challenges as issues of human rights. I also recall the innovative efforts here in Belfast to address housing issues through a rights-based framework. And I can add that efforts here and elsewhere to clarify poverty as a human rights ground of discrimination seem to be gathering growing support. There's one additional step that could radically impact attitudes to rights and to our values would be that for us to try to persuade our national executives to make reference to human rights in the context of all the socioeconomic improvements that they already, or anyway, seek to achieve. I'd like to see them express the delivery of healthcare as an issue of human rights, job strategies as about the right to employment, and similarly regarding education, social welfare, and otherwise. Before moving past the executive arm of government, allow me one further observation. An essential element of the rule of law is the full participation of our peoples in the reflection processes that impact their well-being. In other words, our states can get much better at listening to their people. Across Europe, people complain that consultations on important policy areas are missing or inadequate or tokenistic. This issue of meaningful engagement with policymakers has been flagged for years by civil society. It's especially acute regarding the possibilities of engagement for marginalised groups. Think, for instance, of the degree of exclusion of members of the Roma and traveller communities. Addressing the participation and consultation gaps is a basic issue of rule of law. It will also yield better outcomes, and in the context of my words today, will support the deepening of the trust and the buy-in on the part of citizens. The need to actively listen is particularly acute regarding young people. They correctly complain about the paucity of structured spaces for them within which they can dialogue with decision makers. And in terms of investing in this area, I recall how surveys and other research show that the most disaffected group across our societies is that of young men. We must talk to them. Very closely related to the right of people to be consulted is the importance of respecting rights of peaceful protest. Sometimes the security pendulum swings too far towards the limiting of protest. Just look at the excessive restraints we have seen in recent months in some countries in the context of pro-Palestine and climate crisis-related protest. Let me briefly now mention two other institutions of the state: parliaments and courts. The potential of parliaments in standing up for the rule of law remains underdeveloped. It's still the case that too many European parliaments fail to undertake human rights scrutiny of draft legislation, and some of them lack a related parliamentary committee, with, of course, Westminster being a noted and honourable exception. And I suggest that all parliaments on our continent could benefit from enhanced training on human rights and rule of law for parliamentarians and their staff. Turning to the courts, I appreciate with the deepest of respect the principled manner in which so many of them play their essential role. Indeed, where I come from, a strong argument can be made that the courts were the primary driver of recent great social change. And in that context, when I refer to courts, I have in mind, in my case, not only the Irish domestic courts, but also the European Court of Human Rights. But courts too need investment and attention if they are to function everywhere as the strong independent institutions we require. For a number of European courts, reform of judicial and related prosecutorial services is in urgent need of attention. Courts also, my friends, should not be exposed to unnecessary risk by policymakers who, rather than tackle controversial issues, instead trust that the courts will eventually resolve the matters. This is a phenomenon one can occasionally see behind migration-related cases that arrive at the European Court of Human Rights and the EU Court of Justice. One last word on rule of law-related institutions at the regional and international levels. In troubled times such as now, they are more important than ever. They need to be protected and rendered resilient. For sure, typically, many, if not all of them, could benefit from reform and from revised mandates. But that's well beyond the scope of my lecture today. Suffice for now to flag their vulnerability. Look, for instance, at the situation of the International Criminal Court. And don't forget that history has shown us how institutional weakening has a contagious quality to it. Dear friends, finally, and I've left it to last because I believe it needs high and particular attention, is the question of today, where are we to find our champions of rule of law? We need champions who are persistent and consistent. They need courage. They need to be willing to challenge convention. They have to be able to accept and withstand unpopularity, even derision. For sure, we need exceptional visionary leaders. But such leadership is extremely rare. But we cannot simply rue its scarcity or wait for it to emerge. Instead, for me at least, I look for my hope across the breadth of the political middle ground that I spoke of earlier. For all my current concerns, I see that it is full of decent, honourable, hard-working, well-motivated people. I meet them constantly in my work, whether in national or local parliaments or governments, or in such places as the European Parliament or the Parliamentary Assembly of the Council of Europe. These people of the middle can be engaged and persuaded. We need them to be alert to the gravity of the moment and engage that gravity in law, policy and discourse. We need their attention nationally and beyond. And they, for their part, need our help. Those of us who work for human rights, whether in the public service or in civil society, must present clear, evidence-based arguments for our claims, something I would say that is not always the case. And I'd add that I consider that our claims must always be soundly based on the existing international law standards, something I've argued for repeatedly, but again is a topic beyond my scope this afternoon. But we all also have to acknowledge the complexity of governance and put forward recommendations that reflect that context. And beyond that, of course, it is no less important for us persistently to call out any resiling from minimum acceptable standards. And more generally, we can all do a better job of monitoring and assessing the work of the relevant authorities and bodies. Dear friends, as I conclude, in this lecture, I could do no more than engage the tip of the iceberg in terms of the risks to and the means to uphold the rule of law. There are so many other sectors and contexts to examine and engage. I've said nothing about the role of local government. I've managed an entire speech in 2025 with only the slightest reference to the AI revolution. I've largely overlooked the business sector. I've said by no means enough about content moderation and the tackling of disinformation. But if I have at least shone some light and conveyed the urgency, then my purpose is served. To apply the title of a book of the Norwegian adventurer Thor Heyerdahl, time is short and the water rises. As we all engage the challenge, I know that my own organisation, the Council of Europe, will accompany us. It will provide us with what support it can. After all, it's the organisation's raison d'etre, its only purpose, to uphold human rights, democracy and the rule of law. And I too will employ the breadth of my mandate to support member states, their societies, their rights holders. Personally, I'm confident that the efforts will not be futile, that ultimately we will achieve much and that the rule of law will prevail, at least in Europe. And what's more, in terms of what we face, I recall the words of Nelson Mandela in his famous Make Poverty History speech delivered in Trafalgar Square in London in 2005, where he said, talking to us, "Sometimes it falls upon a generation to be great. You can be that great generation." Thank you.
Thank you very much. You've given us so much to think about. We now do have time, about 20 minutes for questions, and we're very honoured that the Lady Chief Justice is going to stay and also answer questions. Thank you for that. Michael, are you going to?
Yes, I think this.
I should also say that Michael told me that no question is out of bounds for him. He honestly did. So who would like to start? Monica?
Thanks very much, Michael. It's the 3rd anniversary today of the invasion of Ukraine. Where you're sitting right now is a very difficult place. Are there any words of hope that you could give in terms of upholding the rule of law? You did mention that there is a lack of trust sweeping Europe in terms of how we used to respect the international standards. And indeed, I would have to say that when we were negotiating the Good Friday Agreement, it was a good framework for us. What message would you say that we Europeans could actually give to Ukrainians. I was there last week with the politicians and civil society leaders, and they are hopeless in believing that anyone is standing up for the rule of law.
Yeah.
It's an incredibly difficult moment. It's the third anniversary. It's a moment of deep confusion and lack of a sense of what the hell is going on and what's happening. All we know about US initiatives regarding Ukraine is what we read in the media. We hear discussion about land, minerals, transactions, not a word about people. And that's unacceptable. The Northern Ireland peace process was a reminder of, in a way, it was a distillation of decades of good practice in terms of how you build a reliable and an honourable peace, and indeed how you begin a pathway of peace, because it's not delivered in an agreement. It can take many, many years to consolidate. The challenge now is to get to find the ways to infiltrate into the discussions around peace in Ukraine and make sure that our voice is heard, the voice of experience, of global experience. There's so much missing and so much that disturbs me. That picture from Riyadh last week was of a bunch of men around a table. There wasn't a single woman in the room, despite the fact that the UN has shown us over decades now, and Monica, you have, through your leadership, the role of women in peace process. It's not an add-on, it's not some kind of a luxury, it's not some kind of a concession. It's absolutely essential to getting the peace right. So I'll be going back to Kyiv myself in a couple of weeks' time in this new context, but also with a sense, in a way, awful stuff sometimes crystallizes and clarifies for us the need to act. And we've been kind of being a bit nonchalant about engaging with peace process for Ukraine and the missed opportunities. It's time to harness all the energy, bring together the different initiatives and find ways to get into the room, working with Ukrainian partners, because that's the other dimension of this. The idea of a peace that isn't led by Ukraine is obscene. This is their country, their sovereign state, their freedoms. So that's where I'll be going now, see how we can work in support of them to get to the table with all of the global experience so that wherever we go with this process, it has a good outcome. I don't have any massive word of encouragement right now. I'm as confused as everybody else. But maybe just one thing, sorry. Monica, you've been there, you know what I'm talking about. Ukrainians are amazing. They're very, very impressive. They're very confident. They're very self-assured. They have very strong senses of qualities for all the problems of the country, of democracy, of what democracy should and could look like. Civil society is incredibly strong. The Human Rights Ombudsman runs a really impressive institution, just to take two examples. So in engaging with them, we're working with really valuable partners who bring an awful lot to the table.
This one first, Michael, and then here.
Yes, Michael, with respect towards what you said with respect to getting co-equal social economic rights on the calculus of totality of human rights, President Higgins, as you probably know, over the last year in Rome, UN recently, Dublin, but consistently, not just him alone, but addressing that question on the matter of food security, global food security. Council in Europe, so much we know in Europe the question of the migration of peoples, often being driven by hunger from climate and so forth, all interrelated. But in terms of what can be done more in terms of the human rights side, including the Commission here, and also obviously in the wider sense of making sure people understand that question of food security, not easy to deal with, but it seems to get lost in the shuffle of what we talk about, why migration occurs, and dealing with, on the ground level, with human beings, not just a question of olives being hard to get, or tomatoes for us, the price of these things going up, but in terms of those fundamental issues.
Food security I accept, is hugely important. It's not something I deal with directly and immediately, given the nature of my job and mandate, which only covers the member states of the Council of Europe. But nevertheless, I think, if I may say, one of the first issues is terms are sometimes a big turn-off. Food security is a kind of a term that doesn't wake you up. It's like relative poverty, and these are terms that kind of deaden the issue that they're trying to represent. And people only get food security when they see the fact of famine. So maybe we have to do a better job of communicating these issues. The second thing we have to do is protect the institutions that play the essential role in delivering food security. I think of the budget cuts to the World Food Programme, the budget cuts to the Food and Agriculture Organisation at exactly a moment when they need to be strengthened and put at the very heart of the debate. But I wouldn't go beyond that because it's not something I have a direct personal expertise on.
Got one here.
Hello, Michael. I was very interested in what you were saying about the sort of the top-down nature of the disinformation space and the susceptibility of the middle ground to potentially move politically to the right. That idea was the Overton window. But I suppose, what can Europe practically do to protect itself from this, what I see as borderline records of civilization with unlimited resources, almost moving at light speed with AI and everything else? I essentially find them, we can think of these bad actors as sort of techno-fascistic, if I could say that right, sorry. But no, my point is, it seems like something we need to move quickly to protect ourselves against, but also you don't want to end up in a position where you're shielding yourself off from everything and limiting your exposure to things because that may not, if Europe's dictating what we can say and what we can't as well. Long story short, what can we practically do on a European level?
Number one, don't despair, because you'll be tempted to despair if you just look at the sheer overwhelming nature of everything. Second, call out illegality everywhere we see it. Illegality is illegality. I look across to the United States right now, and I don't see enough calling out of illegality. Some for sure, but not enough. More like, oh, this is just dirty politics. Well, actually, often it's just plain illegality. So I went to the European Court of Human Rights last week in a third-party intervention on 3 cases of summary returns on the Belarusian border, arguing that what was being proposed by the states that were at the court was illegal. It was a violation of multiple sources of international law. And so we're waiting now for the court to adjudicate on that. But so I don't want to say any more on it. But we all in our different spaces have different ways of doing this. But don't normalize the unacceptable. Then there's the issue of disinformation. There's an awful lot we can do about disinformation. I said I didn't have time for it today, but there's so much about educating kids, about basic skills of how to spot the fake, and it's not as hard as it looks. Online media literacy. Again, to the extent our different organisations have relevant roles and mandates, challenging the lies as they come across our radar. I used to be director of the EU Fundamental Rights Agency, and back when I started in the job in 2016, there was because of some rapes at New Year in Cologne, there was a great big media attention to migrants as being the instigators of sexual violence in Europe. And we at the Fundamental Rights Agency had just the year before done a Europe-wide survey on sexual violence, which showed it's a very serious problem, but it's an entirely indigenous problem. And that was our way to push back there. And there's many, you could multiply those examples by organisations and by people. Fighting for regulation, not yielding. I spoke about it earlier. This inclination towards deregulation right now. Now, I'm not a global regulation specialist, but in the areas where I'm very concerned, I'm not convinced remotely by the arguments for a pullback of regulation. I gave some examples, but they're based on ideology. The call for deregulation of the social platform space derives from an ideology that is not consistent with international human rights law, and we have to engage it with that understanding. And so, in the UK context, and looking more broadly across the Europe, including the EU, this is a tricky, dangerous moment where leaders are jumping on the deregulation bandwagon without necessarily distinguishing between good and bad regulation and regulation that derives as a necessity from the duty to uphold people's human rights.
Well, I can thank you again. I want to thank Michael. I want to thank Lady Chief Justice. But particularly I want to thank everyone who's given us the time to do what we said we wanted to do today, which was talk about human rights and promote them. And as a reward, we have a little refreshment down at the back. It's not very grand, but it's the most we can afford. And thank you to the bar for also supporting us again. And Donal, thank you very much for having us. Thank you.
Thank you very much.